Justices have ruled that people who are under domestic violence restraining orders cannot possess a firearm.
When Zaki Rahimi was prosecuted for having a gun despite a domestic violence restraining order.
People who had been deemed dangerous because they had domestic violence restraining orders cannot possess firearms.
The Supreme Court is back to hearing arguments in a controversial case dealing with the Second Amendment rights of those convicted of domestic violence.
To make sure that you have to be 21 to buy any kind of gun, not just a handgun, but rifles as well.
And lower court judges that I think have gone too far in striking down all kind of gun laws as violating the Second Amendment.
Can disarm people under the Second Amendment if they are not law-abiding and not responsible.
The Supreme Court just handed down a major ruling in United States v. Rahimi, and depending on who you listen to on social media, it either destroyed your Second Amendment rights or it changed nothing at all. Both of those takes are wrong. What actually happened is more complicated, more important, and honestly more useful to you than either side is admitting. The court ruled 8-1 that individuals subject to domestic violence restraining orders can be temporarily disarmed under federal law. Specifically 18 U.S.C. section 922 GM8. That is the federal statute that prohibits firearm possession while you are under a qualifying protective order. But here is the part nobody is breaking down for you. The way the justices wrote their concurrences, the reasoning they used to get there, that is where the real story lives, and it has massive implications for your due process rights going forward. I am going to break down exactly what this means for you. If you are a lawful gun owner in any state, and especially if you live in a state with red flag laws or aggressive protective order statutes, this ruling touches your life directly. It does not matter if you have never had a protective order filed against you. What matters is the legal standard the Supreme Court just set for when and how the government can separate you from your firearms. And here's the timeline you need to care about. Multiple lower court cases are already working their way through the system right now that will use this ruling as their foundation. Cases challenging red flag statutes in states like New York, California, Illinois, and Florida are going to cite Rahimi in their briefings over the next 6 to 12 months. The legal ground beneath your feet is shifting, and you need to understand which direction it is moving.
The Supreme Court is back to hearing arguments in a controversial case dealing with the Second Amendment rights of those convicted of domestic violence.
Justices have ruled that people who are under domestic violence restraining orders cannot possess a firearm.
The High Court ruled in favor of a federal law that prohibits people under domestic violence restraining orders from having guns.
People who had been deemed dangerous because they had domestic violence restraining orders cannot possess firearms.
Alright, so let me walk you through what actually happened inside this opinion. Chief Justice Roberts wrote the majority opinion, and he was joined by 7 other justices. The lone dissent came from Justice Thomas. The core question in United States v. Rahimi was whether Section 922 G8, the federal ban on gun possession for people under domestic violence restraining orders, violates the Second Amendment under the historical tradition test that the court established in New York State Rifle and Pistol Association v. Bruin, that is the landmark 2022 case that said any modern gun regulation has to have a historical analog. Meaning the government has to show that a similar kind of restriction existed in American history around the time the Second Amendment or the 14th Amendment was ratified.
When Zaki Rahimi was prosecuted for having a gun despite a domestic violence restraining order.
With the Second Amendment, be banned from possessing firearms while that order is in effect.
Lower court judges that I think have gone too far in striking down all kind of gun laws as violating the Second Amendment.
Of different courts grappling with what are those limits, what does it look like, how are we supposed to interpret history and tradition?
The government argued yes. Historical analogs exist. They pointed to surety laws from the 1700s and 1800s, laws that allowed courts to disarm individuals who were found to pose a credible threat to others. The majority agreed. Roberts wrote that the principle behind Section 922 GM8 temporarily disarming someone a court has found to be a credible threat after a hearing is consistent with the nation's historical tradition of firearm regulation. The vote was 8-1. But here's why that number is misleading if you stop there. 5 justices wrote separate concurrences. 5. That almost never happens. Justice Gorsuch wrote a concurrence emphasizing that this ruling is narrow. He specifically said it does not validate every restraining order scheme in the country. He stressed that the protective order in Rahimi's case involved an actual hearing where a judge found a credible threat based on evidence that matters enormously. Justice Kavanaugh wrote separately to reinforce that the Bruin framework is still the law of the land. He was essentially saying, do not read this case as the court backing away from Bruen. Justice Barrett wrote to clarify how courts should apply the historical test going forward, arguing for a principles-based approach rather than a rigid twin-matching exercise. Justice Jackson joined the majority but expressed concern about the historical test being too restrictive in other contexts. And Justice Thomas, in his dissent, argued that the government failed to identify a sufficiently analogous historical law. He argued that Section 922 James 8, as applied, is unconstitutional.
Court is saying that you can have those kind of restrictions consistent with an understanding of the Second Amendment.
It can disarm people under the Second Amendment if they are not law-abiding and not responsible.
But it takes 5 justices to get a majority, and of course today we had 8 united.
The Second Amendment allowed this federal law, which disarms a number of different people. It's really important to note, Lester.
The court tries to finish up by the end of June. There's a chance that they may go into early July.
Now here is where this gets critical for your daily life and your rights. The reason those concurrences matter so much is that lower courts are going to read them very carefully when they decide the next wave of Second Amendment cases, and there are big ones coming. Range v. Attorney General of the United States, a Third Circuit case about whether nonviolent felons can be stripped of gun rights, is directly affected by how courts interpret the Rahimi historical analysis. Then you've got cases challenging state red flag laws, sometimes called Extreme Risk Protection Orders, or ERPOs, states like California under Penal Code Section 1812.5 and New York under CPLR. Section 6340 have red flag statutes that allow firearms to be seized based on petitions that sometimes do not give you a hearing before the seizure happens. That is the key distinction. In Rahimi, the majority went out of its way to emphasize that the restraining order involved an actual judicial hearing. A judge looked at evidence. The respondent had an opportunity to be heard. The due process box was checked, but many red flag laws across the country skip that step. They allow ex parte orders, meaning a judge signs off on the seizure based only on what one side says, without you even being in the room. The Rahimi ruling does not endorse that. In fact, Gorsuch's concurrence practically waves a red flag at red flag laws. He is saying if you do not give the gun owner a meaningful hearing before you take their property and their constitutional rights, you have a serious due process problem under the Fifth Amendment.
Is set to hear oral arguments in a case that could impact what's needed for law enforcement to enter your home without a search warrant.
Unanimously upholds a Montana Supreme Court decision allowing law enforcement to enter a home without a search warrant.
Court has heard oral arguments in Case versus Montana. It's a case tied to the Fourth Amendment.
What's it take for an officer to determine there's an emergency and then enter into your home without a search warrant?
This is where things connect to the bigger picture in a way that should give every gun owner some cautious optimism. The Bruen test is still intact. The court did not water it down. What they said is that when there is a genuine hearing, when there is a credible threat finding based on actual evidence, and when the restriction is temporary, the government can meet its historical burden. That is a high bar, and it is a bar that a lot of current state laws do not clear. Think about what this means for how police interact with you too. If an officer shows up at your door with a protective order and demands you hand over your firearms, the legal question of whether that order was issued with proper due process now has teeth. If the order was issued ex parte without a hearing, defense attorneys across the country are going to challenge the seizure under Rahimi's own logic. If a red flag petition was filed by an estranged family member or a disgruntled neighbor and a judge rubber-stamped it without giving you a chance to respond, that process may not survive constitutional scrutiny anymore.
Some sort of emergency is afoot before they can enter into somebody's house without a warrant.
An officer shot Case after he threw open a closet curtain while holding an object that looked like a gun.
Officers respond to these sometimes very tricky situations that they simply have to act reasonably.
Where the outcome is, it's going to set a constitutional standard for police behavior throughout the entire United States.
Is this a total win? No. Let me be straight with you. The court upheld a federal firearms prohibition. Justice Thomas was the only one willing to strike it down entirely. For anyone who believes Section 922 G8 is fundamentally unconstitutional regardless of due process protections, this is a loss. And there is a real concern that anti-gun lawmakers will read the majority opinion and claim it gives them permission to expand disarmament schemes.
They want more regulation for high-capacity rifle magazines, mandating universal background checks, expanding red flag laws.
To make sure that you have to be 21 to buy any kind of gun, not just a handgun, but rifles as well.
I am not deterred by any smear piece from these legacy media outlets.
The Florida Gun Show, we're told they don't allow private sales. All gun transactions must go through a licensed seller here.
They will cherry pick Robert's language and ignore the concurrences. That is predictable and it will happen. But here is what is also true. The concurrences from Gorsuch, Kavanaugh, and Barrett are a legal roadmap for challenging overbroad state laws. They practically invite lower courts to strike down red flag statutes that lack proper procedural protections. They reinforce that Bruen is not going anywhere, and they raise the evidentiary bar for the government every single time it wants to take your firearms. That is not nothing.
It's like banning cars. Cars kill more people every year than firearms.
The universal background checks we ought to do right now. Banning bump stocks, we ought to get done immediately.
After legal back and forths for years, this is now in the hands of the Florida Supreme Court, and they could vote soon.
We've done $750 million just for school security since 2019.
That is a framework for the next 5 to 10 years of Second Amendment litigation. So here's where things stand for you right now. If you're a lawful gun owner with no protective orders against you, your rights are not affected by this ruling today. If you're in a state with a red flag law, watch the lower courts over the next 12 months because challenges are coming. Rahimi just gave attorneys new ammunition to argue those laws violate due process.
3 Elyria police officers storming into a man's home and arresting him. They did not, we found, have a warrant.
And that is a sufficient legal authority to go and apprehend someone. They have violated the law.
This ruling will allow officers to continue to keep their communities and citizens safe to the best of their abilities.
Ransack your house, arrest or detain you without any judicial warrant. That's a violation of the Fourth Amendment.
If you ever find yourself served with a protective order, get an attorney immediately. The distinction between an ex parte order and one issued after a full hearing is now a constitutional dividing line. And keep your eye on Range v. Attorney General in the Third Circuit, because that case will tell us how far courts are willing to push the Bruen framework on felon disarmament statutes. Your firearms are not being confiscated because of this ruling. Your carry permit is not affected. But the legal chess game over your rights just entered a new phase, and you need to be paying attention. That is it for today, folks. See you in the next video.